Siniakovich and Soudey and others.
Yes.
Good morning, my lady, my lords. I appear for the appellants in the first appeal, who are the second and third defendants in the proceedings. So it's Glassdoor Homeless Charity and Mr. Matthew Falk, who is Glassdoor's Director of Services. My learned friend, Mr. Lima, appears for the respondent, Mr. Siniakovich, who's the claimant in the proceedings. Now, the court has before it two appeals, my client's an appeal and an appeal by the first defendant, Miss Soudey. Now, when Lord Justice Phillips granted permission to appeal, you'll have seen that in Miss Soudey's appeal, he directed that her appeal be listed with my client's appeal, but anticipated that our appeal might be heard first if the court was in agreement with that.
Yes.
I'm not sure if the court's received the correspondence from Miss Soudey, I think overnight.
We've seen an email in which she says that she's content for matters to be dealt with on the papers and that her litigation friend should be watching remotely.
That's all I was going to say, and she just asked that that be brought to the court's
Yes.
attention if it hadn't already made its way through. Just in terms of housekeeping, bundles, first of all, you should have before you in relation to this appeal a core bundle. That includes our permission to appeal skeleton argument, and that also stands as our appeal skeleton. I take that as read, if I may, and adopt everything that's said therein. There is then a supplementary bundle.
Yes.
There's then an authorities bundle from us. That was filed on the 4th of December in both hard and soft copy in accordance with the court's directions. We learned yesterday that it's possible that that bundle hadn't made its way through to the court. I apologise for any omission at our end. It certainly is our understanding that it had been filed on the 4th of December.
Well, it didn't reach, I don't think it reached any
Any
of
of
us
us. No.
until yesterday, but that may not be your fault. It's just
We
something
apologise if it
that
was.
happened.
And then there's also an unagreed authorities bundle that was submitted by the respondent just 2 days ago. I'll leave it to Mr. Lima to address.
Well, I haven't seen that at all as yet.
Is that the one with 7 tabs in it?
Lord, I'm just double checking that. It's 86 pages long, and it is 7 tabs, yes.
Do I have that electronically?
Yeah, it's called a supplementary authorities, but not agreed. Is that what you're saying?
Well,
Not agreed, but we have no objection to any of that being placed before the court.
Thank you.
Now, I understand, I think, from your ladyship's clerk that the court's going to be working in both hard and soft copy. I just asked that question to ensure that I don't burden you with unnecessary tab references.
Yes.
If you're all working electronically.
I'm working on hard copy.
Grateful. I shall give both. In terms of timetabling, I estimate I'll need probably in the region of an hour and a half to an hour and 45. Mr. Lima has indicated that he will need slightly less than that in the court's hands. So by way of introduction, this is an appeal against the order of Deputy Judge Alegre of the 23rd of May, pursuant to which she granted an application to backdate the issue of the claim and to deem that the claim had been brought on the 27th of March of this year. Now, if it would be convenient to the court, I propose addressing the court on the following 6 overarching topics. First, the background covering the claim and what's become known as the backdating application. Second, I'm going to make some observations on the judgment. Third, I'm going to deal with the law, which is going to take a little bit more time. Fourthly, I'm going to deal first with grounds 2 to 4 compendiously. Fifth topic will be ground 1. And finally, I'm going to make some very brief observations on the respondent's notice.
There are 2 points that has occurred to all of us that are not taken and we are surprised by the fact that they have not been taken. The first, which is a pretty fundamental point, is whether a failure to pay the entire correct fee as a result of a mistake means that a claim is not brought for the purpose of the Limitation Act, and there is conflicting authority on that at first instance. It's a difficult point. It's not adverted to by anybody in any skeleton argument, and at the moment I'm wondering how satisfactory it's going to be for us to try and deal with this appeal, because without that argument, because were we to conclude that you were right in the points that you make about procedural unfairness and or mistake of fact, because that point has not been taken, we'd have to send it all back for a fresh hearing, and then there would be presumably an opportunity to take it if somebody so wished. But since it seems to arise pretty strongly on the facts of this case, we're a little bit concerned by the fact that nobody's taken that point. The other blindingly obvious point that nobody has addressed is section 32A. It's mentioned in passing as the proper way to go about curing a mistake of this kind in a case of this kind. But nobody asked the judge, of course, to deal with that. And consequently, we've got no idea how it would be addressed, if at all. That may be less of a glaring problem, because if we have to send the case back, then it can possibly be addressed at that stage. But I'm flagging this up now for your benefit, because at the moment it seems to me that there's an elephant in the room and nobody's actually looked at it.
My lady, I'm very grateful for that indication. In relation to the first of those points, I was proposing to deal with the law on that in a bit of detail.
Yes.
And it was going to be my submission that if we're correct in relation to grounds 2 to 4,
yes,
it would necessarily follow that the claim wasn't brought. It wasn't brought on the 27th of March on any view. But I was going to address you on the law now. In relation to section 32A, your ladyship's right to mention that it's mentioned in passing. Our position on that is that if we're right in relation to this appeal, it would then fall to the claimant, if he so wished, to make an application to disapply section 4A of the Limitation Act in relation to his claims for libel and malicious falsehood.
So you would be arguing that the failure to lodge the correct fee is fatal because the claim is not brought. Now, I have to ask, Mr. Lamar, are you in a position to deal with that point?
My lady, yes. I'd anticipated, given the way that permission was granted in this case, that the court would be looking at the question as to whether or not the non-payment of fee is one of the relevant matters that needs to be done in order for a claim to be brought under the Limitation Act. So certainly yes, I'm obviously aware of all of the first instance authorities. That's why I put another one, if I think of them in.
Yes.
So not in a difficulty insofar as addressing that on my feet. I do recognise that the way that the written cases, which neither myself nor my learned friend are responsible for, have been put in, that's not set out in writing. Now, it may be that the court says, well, you'd rather see all of that set out in writing first, rather than having it dealt with orally, and of course that's a matter for the court, and I understand that.
Well, as long as you're not taken by
not
surprise
at all
by
by
it.
that, no.
I mean, it's obviously handicaps us to an extent
Yeah.
not to have seen the arguments canvassed in writing.
Yeah.
But my concern is much more about fairness to you.
Yeah.
If you feel that you're in a position to be able to address it, let's see how we get on.
Sorry, can I just say, in relation to the second point, I agree with my learned friend.
Yes.
That only comes into play if we lose and the
Yes.
claim is not brought. Then
And it's
there
still
is
open.
Yeah, indeed.
Right. Thank you.
And maybe I should add that if it would be of assistance to the court, speaking for myself, but I'm sure my learned friend as well, we can put in further written submissions on any particular points that...
Well, let's see how we get on. Thank you, Mr. Wills.
Turning to topic 1, if I may, and that's the background. In relation to the claim, I don't propose saying very much about it, but there's a number of short points that I want to make just to contextualise what is going to follow. So insofar as it concerns my clients, the second and third defendants, the claim arises from their disseminating 2 safeguarding alerts by email. These related to safeguarding concerns that they had in respect of the claimant who's someone who had attended their sites. They were sent respectively on the 28th of March 2024 and the 5th of April 2024. I don't think we need to turn them up, but for the court's note, they're at supplementary bundle, tab 4, pages 27 to 28, and also page 30. The claims against Glassdoor and Mr. Falk are for libel, breaches of data protection legislation, and negligence. And there is also a malicious falsehood claim against Mr. Falk. Now, if I may invite the court to turn up the claim form, that's in core bundle tab 6, page 51. You'll see the endorsement there. I should mention it mentions a misuse of private information claim, but there isn't in fact any pleaded claim in relation to that in the particulars. You'll see there that the claimant seeks damages in the sum of £370,000. And then you'll see in the bottom right of the claim form, you'll see the court fee that the claimant's solicitors had calculated and put on to the claim form. If I could just invite you then to move directly to the particulars of claim which follow that document. They're at page 56 behind the same tab. The only part of this that I propose showing you, my lady, is page 70. And there you see the relief sought. So you see reference to the damages, that also features on the claim form. You've then got an injunction preventing the defendants from further publishing, republishing, defamatory allegations, etc. Fairly standard in a libel case. You've then got reference to a retraction and apology. And then if you go over the page, please, at subpara 4, so this is on page 71, you see that there's also an order under section 167 of the Data Protection Act and all the court's inherent jurisdiction requiring the defendants to erase personal data, etc.
Yeah.
That is known as a compliance order in the law of data protection. And I'll come back in a moment to that, because you say that also has some relevance, because not only the injunction that is mentioned there as a non-money claim, but also that.
Can you just remind me whether we know who the author of the particulars of claim was?
Yeah. So, my lord, it's Counsel Anthony Iskander.
Have I missed his name?
I'm not sure if it's on
He's
the...
not signed it.
Not signed it.
No.
Sorry, if I may,
Right.
the way that I knew this is that I think it's referred to in the witness statement of the claimant solicitor dated the 7th of April. And I can turn that up. Sorry. Not sure if Mr. Lima can assist me. I'm fairly sure I have seen that.
It can come up later. I didn't want to take you out of your course. It just occurred to me as we were going through the document.
Of course, the particulars of claim didn't have to be served in order to issue proceedings, did they?
That's correct, my lady. It's been within 14 days thereafter, unless a defendant has asked that they exercise the power under the CPR, or the right under the CPR, to ask for them to be served sooner. That's correct.
So it's only the consequence of choosing to serve them at the same time that results in an increase in the payable fee.
Well, yes, my lady, I'll come on in a moment to the case law that discusses this point. But it's the short point is that the court has to look at the claim in its totality as presented to it
Yes.
at the point that it's presented to it. Now, if I may come on to the, still on the background, the attempt to file proceedings, if I can put it that way. So the limitation period for the libel and malicious falsehood claims would, pursuant to Section 4A of the Limitation Act, have been 1 year from the date when the cause of action accrued. So that's when the safeguarding emails, in this case, were published. Now, 1 day before the expiry of limitation of the libel and malicious, for the libel and malicious falsehood claims, the claimant solicitors sought to file proceedings. It was on the 27th of March, and the claim form and particulars of claim, as my lady has already pointed out, were filed together. I don't think we need to go to it, but the filing receipt appears to be at Core Bundle tab 7, 87 to 88. Now, the court rejected this filing on the 7th of April. We don't have what's been referred to as the rejection notice in the bundles as far as I can see, but we do have what I think is accepted to be an accurate copy of it at paragraph 8 of the judgment of Deputy Judge Alegre. You can find that at tab 5 of the core bundle, page 47.
Melanie, I don't wish to interrupt my learned friend, but I noticed that that wasn't before the court, the rejection notice. So I did ask for it and it got emailed to me. So I printed off copies if the court wants to see it.
As long as it's the same as
I'll
what we
double
put
check
in the
there's nothing in-
judgment,
yeah.
I think
I'm grateful. Thank you, Mr.
completeness
Tillman.
would be useful.
So perhaps invite the court just to read what's at paragraph 8.
Yes.
But the short point is that the claimant requested an injunction in the particulars of claim, and that therefore an additional fee of...
You haven't paid the full fee, is what they're saying.
Exactly so, my lady. And therefore the court didn't issue the claim. Now, on the same day, the 7th of April of this year, the claimant refiled the claim form and the particulars of claim in identical terms to the way they were when they were originally filed, and they paid $10,626, so the issue fee for the money claim and the non-money claim, and I'll come on in a moment briefly to how that's calculated. And there, having done that, the following day, the court issued the claim on the, on the 8th of April, and you'll have seen the seal on the claim form to that date. Now, coming on to the backdating application, so also on the 7th of April, the claimant made 2 without notice applications. There was an application for an interim injunction to restrain the defendants from publishing defamatory material. I'm not going to take you to it unless that will be of assistance, but for your note, that's at Supplementary Bundle, tab 3, page 17. I'm not sure we have any evidence on this, but it's reasonable to assume that an application fee, a separate application fee, would have been paid for that, albeit it would have been the fee for a without notice application rather than the fee for a non-notice application. That application was later withdrawn. Don't propose saying anything more about that. But alongside that, there was an application, it's become known in these proceedings as the backdating application. And if I may take the court to that, it's in the Supplementary Bundle, tab 2, page 5.
It says it's an application under 3.10.
So 3.10 and 3.12M, and or the court's inherent jurisdiction, that the court treat the claim as having been issued on the original date of submission, or to permit what the notice refers to as retrospective issue, and that would of course be back to the 27th of March. Now I should say, as the court's already noted, that there's no application here or anywhere else for, under section 32A of the Limitation Act, to disapply the time limit for bringing the claim. Now, if I may take the court to the evidence that was initially relied on in support of that backdating application, and that's just behind the application notice that you've been looking at page 10 of the same tab. And there, Miss Badabitana, sorry, I hope I'm pronouncing her name correctly, explains that an N244, which the court will know is an application notice for an injunction, was unintentionally omitted from the filing. And she then said that an unspecified system didn't trigger the correct fee.
Sorry, can you just remind me where you are?
I apologise, my lord. Paragraph 8. So page 11 of the supplementary. Do you have that?
Yes. Yep, thank you.
I should just say as an aside, that point appears to misunderstand the obvious point that one doesn't have to file an N244 application notice when filing a claim that includes a claim for final relief.
The N244 would be for any interim relief, which would presumably happen on the 7th.
Precisely so, my lady. It was said by the claimant's solicitor, and this is at paragraph 11, that it was an administrative and technical oversight, and she also blamed the lack of an automated system, flag or notification in CE file to identify the missing injunction or material fee. So in essence, I would respectfully suggest she was seeking to place some of the blame on the court for not having such a system in place. Now I would note there, my lady, my lords, that there's no suggestion in that statement that the claimant didn't intend to seek an injunction. To the contrary, his solicitor said it had been inadvertently omitted. There was no application as to why, there was no explanation as to why the application had been made without notice. We say that that was plainly inappropriate, particularly given the issues that application raised in terms of the proceedings generally, and in particular for the defendants.
This is the application.
The backdating application, although we would make the same point in relation to the application for an interim injunction, but that doesn't concern us here. And then these applications having been filed and issued, these matters came before Aidan Eardley KC sitting as a deputy judge, and we see at tab 1, page 2 of the supplementary bundle that the deputy judge directed that the applications be served on the defendants. He gave directions for the filing of evidence, and importantly, the defendants were to file any evidence 10 days before a hearing of these applications. Any reply evidence was to be filed 7 days before the hearing. And if I may just invite the court to go to page 4, so the last page of the deputy judge's order. And in letter C of his reasons in relation to the backdating application, the deputy judge flags the potential concern in relation to limitation, and indeed that is part of his explaining why notice needed to be given. A hearing was then listed for the 21st of May. On the 16th of May, the claimant's solicitor filed further evidence that was served, I understand, on the defendants on the 19th of May, so just 2 days before the hearing. 2 points to make about that. This wasn't responsive evidence per the deputy judge's order because the defendants hadn't filed evidence that could be responded to, but it was also filed in breach of the directions that any evidence be filed 7 days before the hearing. But may I ask the court to turn up that statement, please? That's at Supplementary Bundle, tab 2, page 13.
So when was it filed?
I understand it was filed. Well, there's some. I was going to mention this in a minute, Melody, because this same statement appears to have been filed again on the 19th with a different date below the statement of truth. We don't understand there to be any difference of substance as between the version filed on the 16th and 19th. But what remains the case is it wasn't served until the 19th. And if you have the statement before you, you'll see that it's the supplemental witness statement of the claimant's solicitor, and what the application had now become, or it had additionally become, was an application for relief from sanction under CPR 3.9. And you can see at paragraph 2 that what had happened was referred to as a procedural error, and the solicitor went on to explain personal and medical circumstances that contributed to that. I don't propose saying anything about those sensitive matters here today. And then at paragraph 6 over the page, Ms. Badavitano goes on to explain, sorry, this, my lord, is where we see reference to the barrister, the top of page 14, paragraph 6 of the statement.
Thank you.
The solicitor goes on to explain that she didn't read the particulars of claim before filing them, and therefore didn't know that injunctive relief had been pleaded, and this led to what she describes as administrative oversight and failure to include the application notice for an injunction and the additional relevant fee. And then at paragraph 7, she disputes that the wrong fee was paid on the 27th of March on the basis that the claim form didn't itself include a claim for an injunction. So in this statement, Ms. Badavitano appears to have been of the belief that the claim was rejected because there was no application notice for an injunction or the additional fee for that, and not because the wrong issue fee had been paid.
No, she says quite the contrary. She says the right issue fee was paid because all the claim form didn't include the injunction.
And then at paragraph 12, she unfairly, in my submission, criticises the court for not notifying the claimant of its failure to do this, its failure to issue an application notice, as I read it. Then, as I said, there was a third statement on the 19th of May, but that appears to be substantially the same. Mr. Lima will correct me if I'm wrong about that. And again, nothing in that further batch of evidence suggests that the claimant didn't intend to bring a claim for an injunction. Unless I can assist the court further on the background facts, I propose moving forward to making some observations on the judgment and the order under appeal, if I may. So the matter came before the Deputy Judge on the 21st of May, as I've said. The evidence that I've referred to was before the court at that hearing. Now, Claimant's counsel, who I should emphasise wasn't Mr. Iskander, and who hadn't settled the skeleton argument for that hearing, advanced a new point at the hearing that the claimant had never intended to seek an injunction as part of the claim. And that point was made by counsel despite this not appearing in the evidence that was before the court. If I can take you, my lady, my lords, to the tab 5 of the core bundle, page 46, that's where we have the judgment of the Deputy Judge. I'm just going to walk through what we say are a number of key points in that. So at paragraph 1, she explains that it's an application to backdate the issue of the proceedings. Sorry, my lady, I'm cantering on too fast.
It's all right. I'll catch you up. Yes.
So an application to backdate the issue of the proceedings. Then she goes on at paragraph 6 to frame what she describes as the main issue as being whether the claimant can obtain an order that retrospectively backdates the date of issue to the date of the original failed filing attempt, taking into account all of the circumstances of the case. And we see at paragraph 12 on the following page that the judge approached this by asking first what the factual error was in the filing, and secondly whether or not the claim was brought in time.
I mean, all of this is fundamentally misconceived. You cannot backdate a date of issue. Date of issue is the date when the seal is placed on the claim form. That's what the rules say.
Well, my lady, I was going to come on to that and to your ladyship's recent judgment that touches on that issue in the case of Barley.
Yeah.
Then, at paragraph 16, it appears that the judge approached the application on the basis that the claimant had not in fact paid a higher issue fee when the claim was refiled on the 7th of April, prior to it being issued on the 8th. And that's because she says there that the fee for the claim form effectively remained £10,000. But she then notes that there was an additional fee for what she called the N244 claim, which we assume was a reference to the application notice for the interim injunction. And then it seems that the factual error identified by the judge was the inclusion of the claim for injunctive relief in the particulars of claim, and that the pleadings were submitted in error. And we see that at paragraphs 24 and 26. But the judge says at 24 that the claim form and fee paid were in fact correct.
Can you just go back to 16, which is where the judge was talking about the claim form not being changed and there being no material difference. Is your submission that the judge is there making the same mistake that you've identified in the evidence of confusing the fee for the issue of the claim form with the fee for the N244 claim, or what?
My lord, I in my respectful submission, it's not entirely clear what the judge is doing there, but it appears that she may well have picked that up from what was being said by the claimant and perhaps misunderstood the distinction between an injunction that is included as a claim for final relief in a claim form and an interim injunction and, of course, the separate need
because
to pay.
As I understand it, that all that had been withdrawn was the interim injunction.
Yes, later after issue, that's correct, my lord.
There'd been no application to amend the particulars of claim.
No, exactly as I hope I said earlier, exactly the same particulars of claim had been refiled on the 7th, and then that had been issued, well, the claim form had been issued on the 8th. So, as I said, the judge said at 24 that the claim form and fee paid were correct, and therefore she concluded that the claim could properly be considered to have been brought on the 27th of March and allowed the backdating application to do what she said was to reflect the factual reality that the claim was brought within the limitation period on 27th of March. Now, in my respectful submission, it's not at all clear on what basis the deputy judge purported to exercise this jurisdiction to backdate all of this. We know that the application was put with reference to CPR 3.10, CPR 3.9 and CPR 3.1M, but the judge doesn't deal with this at all. It's possible that the deputy judge granted relief from sanctions in the alternative, but I would respectfully submit it's not at all clear on the face of the judgment. Now, finally, if I may, just go to the order. So that's at tab 4. If you go back to page 44, still in the core bundle. And in particular, so page 45, paragraph 4, you see that the backdating application is granted, and one sees in the recital to the order that the backdating application is defined by the judge as relief pursuant to CPR 3.10 and or CPR 3.12p to treat the claim as having been issued on the 27th of March. That is how it's defined, and that is what is granted. And then at paragraph 5, the court deems that the claim has been brought on the 27th of March.
Well, the two is completely different things. The time when the claim is brought is different from the time when the claim is issued.
Well, my lady, we respectfully agree, and that was one of the short propositions of law that I was now going to turn to, if that's convenient.
We'll see in due course what Mr. Miles says.
If it helps, I
that.
don't dispute that proposition at all. They're two different concepts. Yeah.
Yeah.
Turning to my third topic, unless there was anything else I can assist with in relation to the judgment, I want to begin with 8 short propositions of law. I don't understand or anticipate that these will be controversial, but in my submission they're important just in terms of mapping the legal landscape in which this appeal arises. Firstly, as has just been noted, the bringing of an action and the issuance of a claim are of course two different things. The former is an act done by the claimant, taking the steps that are necessary that they need to take to lodge or to file a claim. The latter is done by the court, and that is of course when the proceedings start. I'll come back in a moment to what that means with reference to court fees. But of course it stands to reason that bringing happens before issuing. And if a claim has been issued, it also stands to reason that it must necessarily have been brought. Second proposition, a claim is issued on the date that's entered on the claim form. Again, I don't anticipate that can be controversial. That's in CPR 7.22. Third, the court doesn't have jurisdiction to backdate the issue of a claim form. And as I alluded to earlier, authority for that proposition can be found in my Lady Justice Andrews' decision in the Barley and 1-2 Couriers case. I was going to take the court to it very briefly, but I'm not sure whether my learned friend's authority bundles have arrived as I was addressing you.
Yeah. So they have them electronically, but these are the hard copies.
So I have one. I just want to make sure that the court does. Thank you.
They're both the same. I don't know anyone else wants to.
And do my lords have this electronically?
Yes.
Thank you. I also have it electronically, but it's always nice to have it in hard. Thank you.
So if I can take you briefly to the Barley case. This is at tab 6, page 67 of that bundle. Hopefully the page numbering is the same in the PDF version and on paper. And so this was a case that, well, as my lady will know, was primarily concerned with the issue of extension of time for service of a claim form. But if I can take you to paragraph 28. And if I could just invite the court to read the part of that paragraph beginning the key question. This is that the Court of Appeal addressed in referring back to the case of Walton. And if I could just ask you to keep that authority open or to keep a tab in it for the moment, my lady, my lords. Fourth proposition. For the purposes of limitation, the relevant question is when a claim is brought and not, of course, when it's issued. But those dates may, in some cases, be the same. Don't propose taking you to any authority for that proposition. Fifth proposition, court fees for starting proceedings have to be paid before the court will issue proceedings. And they are calculated by reference to the Civil Proceedings Fees Order 2008 as amended. I'll come back to that in a moment. But if you still have Barley open, at paragraphs 35 to 36 on page 75 of the bundle, there my lady explains that the payment of an issue fee is a necessary precondition to issue. I think your ladyship describes it there as the most important precondition.
To issue, yes. What happened in that case was that there was no payment of any fee until several months after the claim had been brought. Because what happened was that they lodged a help with fees form, and the court office then had to work out how much contribution the claimant had to make towards the fees, and there was then a lot of mucking around by the solicitors, which led to that money being paid some 8 or 9 months after the claim was brought.
Grateful. And then proposition number 6, a claim for an injunction is a non-money claim within the meaning of the fees order. If there's any dispute about that, as I would submit, is a claim for a compliance order under the Data Protection Act of 2018. 7th proposition, if a claim for an injunction or other non-monetary relief is brought alongside a money claim, that will attract the fees for both. And if I may just show you briefly the fees order. So that's back in the main authorities bundle. Tab 3, page 22. And do you have that, my lady?
Main authorities.
Sorry, yes, I'll slow down slightly. Tab 3, page 22 of the main authorities bundle.
Yes.
And that is the schedule to the fees, or that's amended annually, but this is the version in the bundle is the one that was in force, as you see, from the top until the 7th of April. So it was the one that applied at the material time. Just a few points to show you there. So you see that the starting proceedings, and in column 1, you've got the different claim values. This claim was at I, so a claim that exceeds 200,000 or is not limited. That attracts an issue fee for that part of the claim of £10,000. And then if you go down to 1.5, so 4 boxes from the bottom on the left-hand side, proceedings for any other remedy, you see in the High Court £626. And then over the page, you see in the 3rd box that where a claim for money is additional to a non-money claim, fee payable, then the fee 1.1 is payable in addition to 1.5. But it is specified 3 boxes below that if you've got more than one non-monetary remedy being sought, you only pay that part of the fee once. And my
Yes.
My 8th and final proposition is that when looking at what a claim is for, or what is being claimed for fees purposes, one has to look both at the claim form and the particulars of claim, if those particulars are filed at the same time as filing the claim form. And if I may take you to authority for this briefly. So first of all, to my Lord Justice Warby's decision in the case of Batty and Ashgar. That's at authorities tab 8, page 91. I'm going to come back to that case in a moment, but for the moment I'm just citing it for what it says in relation to this issue on my 8th proposition. I can take you to paragraph 35, where my lord explains that the assessment of what was a correct fee must be based on the documents presented to the court at the time of issue. That is to say, the claim form, and if it is available, particulars of claim. One must take the claim to be stated as stated in those documents. And then if I may also take you to the decision of Mr. Justice Stuart Smith, as he then was, in the Dixon and Radley House case. That is at tab 9 of the same bundle, page 100. It starts at page 106. And if I could ask you to turn forward, please, to paragraph 53, which should be at page 131. And there, Mr. Justice Stuart Smith cites with approval what my lord, Mr. Justice Warby, as he then was, said in Barty in relation to assessing claim forms and particulars together. Close the authorities for the moment. So those are my 8 propositions. Now next I want to turn to what may be a more meaty issue of law, and that's the question as to what is required in terms of the payment of claim or issue fees in order for a claimant to be regarded as having brought proceedings. I'm addressing that issue because even if it is accepted that the judge was wrong to backdate the issue of the claim, there would still be a question as to whether the claim was brought at an earlier date. We say it wasn't, for reasons that I'll come on to. But before getting there, I think I need to address the law on this, and I'm afraid it's going to involve a bit of a journey through some of the case law. They're not strictly speaking all first instance authorities, because many of them are High Court decisions on appeals, but High Court authorities and one Court of Appeal authority. And I think it's right to point out that it's previously been observed by this court that there are some tensions in the High Court decision on this issue.
Right.
I'll show you that in a moment.
That's Peter Jackson. Lord Justice Peter Jackson.
I'm going, but in the case of Butters.
Echoed, I think, by Lord Justice Coulson more recently.
Oh, okay, I wasn't aware of that authority, my lord. But
Chelfat.
There's a case called Chelfat,
And
which is
Hutchinson's
slightly off the
3G.
point, but there's so many penumbral features of this
I'm grateful.
procedural landscape.
Can certainly look
It's
at that over
the case is, let me have a look.
I'm grateful, my lord.
Give you the
No, we can look it up over the short adjournment.
It's 2022 One Weekly Law Reports 3613.
Grateful. But what I was going to say is that in my submission, the issues that have given rise to the difficulties in those High Court decisions and some of the tensions between them don't arise here, and in my submission don't need to be determined on this appeal. And in short, and I will come on to this in more detail, that's because this is a case that concerns what happened prior to the court accepting any issue fee and issuing a claim. It's not a case that raises the more, if I may put it, knotty issue of what happens when an issued fee has been accepted, a claim has been issued, and it's subsequently argued that the claim was incorrect, or that something changes in the claim that demands a higher issue fee. In my submission, those scenarios are distinct, and support for that can be found in the case law that I'll come on to in a moment.
So that's where the claim is in fact issued.
Where the claim is in fact issued, the court has accepted a fee, and someone later says, for example, you deliberately understated the value of the claim.
You don't suggest that would be...
No, there's not suggest that doesn't apply here because this all happened prior to the court agreeing to issue the claim, prior to the court accepting the fee. The first case that I wanted to deal with, and I will try to deal with these as briefly as I can, Page and Hewitt solicitors. This is the judgment of this court. I'm going to call this page number 1, and that is at Authorities Bundle tab 4, page 24. Do you have that?
Yes, thank you.
Great. So this was an appeal against summary judgment on the basis that the claim was statute barred, and essentially there was a question about whether the claim documents ever reached the court office. And Lord Justice Lewison made observations about the issue of when an action is to be regarded as being brought for limitation purposes, including citing the well-known decision of Lord Justice Tuckey in the Barnes case. You see that at paragraph 30 of Lord Justice Lewison's judgment. And the claimants in that case had to establish that the proceedings had been brought in time. Lord Justice Lewison held that the courts below had been wrong to focus on when it was issued, and there was a need for a factual inquiry as to what had happened to assess when it had been brought, if indeed at all. And he directed that the issue be remitted for proper consideration of what had in fact happened, and that became page number 2, which I'll come on to shortly. Now, I think it's right to observe that this was not a case that was concerned with issues, or not at this stage, a case that was concerned with issues around issue fees. But Lord Justice Lewison did observe at several points, in particular at paragraphs 33 and 38, that part of bringing proceedings was ensuring that a request to issue proceedings, the claim form that you file, is accompanied by what he referred to as an appropriate fee. And you see that most clearly at paragraph 38 on page 38.
Well, that's just quoting what Lord Justice Tuckey said in Barnes.
At 38, he essentially repeats that.
Yes.
And now I think it's also fair to point out that in the more recent case of Hayes and Butters, which I will come back to in a moment, Lord Justice Lewison himself noted that the correctness or otherwise of the fee wasn't an issue in that appeal before him, and he also cautioned against reading those observations, as one often sees,
Yes.
in judicial observations, as if they were a statutory test.
Yeah.
As I
what
said,
you can say, I suppose, is going back to Lord Justice Tuckey, the rationale, the time at which claimant brings his claim form with a request that it be issued is something he has to do. The time at which his request is complied with is not because it is done by the court and it's something over which he has no real control. So if that is where the bright line is to be drawn, you would say what he has to do is pay the money, and that is not something for the court, that is something for him to work out, and if he gets it wrong, then subject to any provisions of statute that allow you to be alleviated for the consequences of that sort of mistake, you haven't brought your claim because you haven't done everything that's within your power to do.
We would respectfully agree, and also there are subsequent authorities that I'm going to show you where essentially that is the thread that runs through.
Yeah.
Just in relation to that, of course, ordinarily what would happen is that if you sought to pay the wrong fee, the court would, as here, point that out, and you would have the opportunity to pay the correct fee. But of course, the risk that is taken by litigants who do this right at the end of the litigation period is exactly what happened in this case. Now, page number 2. So this is, sorry, that's next tab, tab 5, page 40, it begins. This is when Page was remitted to the High Court for the trial of the issue of whether the claimants had in fact brought their proceedings before the expiry of limitation. And that was heard by Mr. Justice Hilliard. And a discrete issue emerged in that context as to whether the correct court fees had been paid at the right time. The facts, I would submit, don't matter, but the claim related to the sale of a property and somebody allegedly obtaining secret profits unlawfully. You see at paragraph 11 that one of the issues that Mr. Justice Hilliard, and the one I'm focusing on here, 11.2, was were the documents received in good order for issue and accompanied by the appropriate court fee. And what had happened is that a £990 fee had been paid on the 4th of February for the money claim, but the court, rather like in this case, said to the claimant solicitors, you need to pay £400 more because this isn't only a money claim. That's referred, I'm not going to take you to it, but for your notes, it's at paragraph 28, you see that explained. That was eventually paid on the 13th of February. So 4th of February, that was eventually paid on the 13th of February, but limitation had expired on the 6th of February, and you see that at paragraph 45. And the judge therefore had to consider whether or not this meant that the claim wasn't brought for limitation purposes until the correct fee had been paid. And if I may take you to Mr. Justice Hilliard's reasons at paragraph 44 and onwards, it's at page 51. So he noted Lord Justice Lewison's observations in page 1 about the appropriate fee.
Well, he treated that as binding authority on him, didn't he?
That's correct, my lady. And he expressed a view that this formed part of what a claimant has to establish. He held that the claim for an account of profits qualified as proceedings for another remedy, and therefore it did attract the additional fee of £400. And that therefore the court had been correct in its assessment that the fee that had been offered was too low. And despite expressing some misgivings about the fate of the claim depending on this, he held that the claimant hadn't done all that he could, all that was required of them to bring the action, and therefore they'd left it, and they'd also left it too late to correct the error. Now that is the case, of the authorities, that is the case that is most factually similar to what happened in this case. There's then the case of Lewis and Ward Hadaway, which I'm not going to take you to unless you would like me to do so. That also sort of forms part of the background. Essentially, that was a case that concerned an abusive understatement of issue fees. But those issue fees were accepted by the court and the court issued the proceedings. And John Mayle, QC, sitting as a deputy, granted summary judgment to defendants on the basis that a payment of an issue fee that was an abusive process couldn't be regarded as an appropriate fee, and therefore the claims had not been brought until the balance was paid, but that was after the expiry of limitation.
In a case where the fee is £10,000 and I pay £10,500, what happens? Does the court return that and say wrong amount, or does it accept it as to part?
That's a good question, my lord, to which I don't know the answer. I would assume in that situation it would be, because as I understand it, most solicitors would have accounts, and it would be refunded. If you overpay, it wouldn't be regarded as an incorrect fee in the sense that we've been discussing here. But I don't know.
Might be different if it's a litigant in person. You have to have an account in order to pay a fee.
I'm sorry. I can take instructions.
Might be worth just.
You don't have to have an account. In Bali, what happened was they tried to take the money out of the solicitor's account. There wasn't enough money in it, and therefore they had to accept it by cheque.
If I may now go to my Lord Justice Warby's decision when he was High Court judge in Butte, which we briefly looked at before. That's at tab 8, page 91. It was a case about the sale of properties. Now, this issue came up in very different circumstances to the present case, because again, the court had accepted the issue fee, and proceedings had been in train for 18 months when the defendant sought summary disposal of the claims on the basis that the claims included claims for further or other relief, and in one of the cases, the particulars of claim that were filed and served after the claim form contained claims for a higher level of damages than had been reflected in the claim forms. And they hadn't paid the difference in those court fees, as I understand it. You see that at paragraphs 25 to 27. I'm not going to invite you to read unless that would be of assistance. Page 99. Mr. Justice Warby cited the decisions in Page and Lewis and noted at paragraph 30 that the authorities show that the court's approach is and should be strict in respect of this issue. But at paragraph 34, Mr. Justice Warby noted that a failing on the part of the court, such as miscalculating the fee at the time of presenting the claim, might nevertheless lead to a claim being brought for limitation purposes in time, even though the correct fee wasn't paid. Because there, in my submission, the effect of what would be happening in that scenario is that the claimant's done what is required of them, and that's then a mistake on the court's side. And in that situation, a claim may be recognised or declared to have been brought in good time.
Well, how could that ever arise in circumstances where you say it's incumbent on a claimant to look at the order and work out whether or not his claim is for a non-monetary order? I'm just thinking about the practicalities. How can you have a situation where the court makes a mistake?
Well, my lady, I'm slightly in the territory of hypothesising here, but I suppose what could happen is that there could be a discussion between a claimant, for example, a litigant in person, and the court, where the court says you need to pay X fee, and it later transpires that X fee was in fact too low, having regard to what was in the claim form. And that clearly wouldn't be...
Well, on the facts of this case of Batty, which I reread this morning, the argument put forward by Mr. Challenger was that what had happened was that someone took all the documents to court with a blank cheque and asked the court what the right fee was. So whether or not that was right on the facts, it was obviously it was thought by someone that that was a scenario that could occur.
And your lordship concluded that there was an underpayment of the fees and that the limitation period had therefore expired, but declined to summarily dispose of the claim. The issue was left to trial, as your lordship will remember, and that was in essence because no limitation, this had been raised 18 months into the proceedings, no limitation defence had been pleaded, and the claimants hadn't even been given proper notice that a limitation point like this was being taken.
How does any of this fit in with a situation where the claimant is going to ask for help with fees and won't know what the correct fee is for several months? Now, they may or may not get the assistance. If they don't get the assistance, they should have paid the fee themselves. If they do get the assistance, they end up paying something towards it, or nothing towards it, as the case may be. If they pay something towards it, they're paying the correct fee further down the line. in both cases, they have not paid the fee at the time when the proceedings were lodged.
Lady, I must confess, I don't know how it works as a matter of procedure in terms of fee remissions, or whether you have to pay and there's then reimbursement, or whether you simply don't have to pay.
You put in a help with fees form seeking help, which is lodged at the same time as your claim form.
And it may be that in that situation it would be said that a claimant has done all that is required of them in terms of taking steps with the court to bring their claim. I suppose there might be scope for more complex varieties of that scenario, where somebody was doing that in some way abusively, asking for help with fees when they knew very well they had no prospect of securing a reduction or a remission.
Well, we can always make exceptions for abusive behaviour because that's a given. But assuming that somebody's acting bona fides, you say, well, there is a distinction to be drawn between a case where somebody's not genuinely seeking help with fees and has the burden is on them to work out how much is due and how much they should pay, and a scenario where somebody genuinely is, they don't have to pay anything at that stage until such time as the court does various calculations and tells them how much.
Would respectfully agree.
Yes. All right.
Do you know if the court will issue the claim in a case where help with fees is sought?
I don't immediately know the answer to that, my lord, but I can certainly...
Not until it's paid.
Okay.
Sorry, my lady.
Sorry, it's not until it's paid. I only know this because of Barley, because that's exactly what happened in the Barley case.
Okay.
What happened in the Barley case was they lodged the claim form. There wasn't the wrinkle of the particulars of claim. They lodged the claim form and a help with fees form on the last day of the limitation period, very last day. The issue was about whether or not they'd done everything, taken reasonable steps to effect service of the claim form, and so there was a question about when it was going to be issued. But there was a lot of toing and froing between the court office and the solicitors about how much was due and how it should be paid, and that went on for the best part of a year. So the claim form wasn't actually issued until after the fees were paid, and the court office said, we're not going to pay it until after you put in the amount that we say should be given to us by way of help with fees. So the solicitors tried and failed, I think, 3 times to pay the money, partly because there wasn't enough in the account, and then they gave a cheque, and then the court office thought it hadn't been paid when it had. And it went on and on and on, and eventually they issued the claim form about 18 months after the original documents had been lodged with the court office. And the question, and then of course they sent it out, and the solicitors didn't serve it within the period prescribed for service. So that's what we were concentrating on. But the reason that it sort of came into my mind is because if there is a bright line, it's got to be drawn in a way which is going to cut not just in cases where you're dealing with a short limitation period like this one, where you've got statutory relief. It's got to apply across the board to all types of claim.
I can certainly see that, my lady, yes.
But you say anyway that the distinction is that if the bright line depends upon what it is incumbent on the claimant to do, then if somebody is impecunious and they ask for help with fees, then that's good enough.
That's correct, mate. That would be our position in that particular scenario. If I may take you to the next case, and I would respectfully submit this is quite an important one, and that's the judgment of Mr. Justice Stuart Smith in the Dixon and Radley House case. We briefly looked at it earlier in relation to the looking at claim forms and particulars together. Now going to rely on it for different purposes. So this was the claim related to failings surrounding the refurbishment of a house. So I don't know if I gave the bundle reference. It's at tab 9, page 106 it starts. And there was an application, a judgment on application by the defendants to amend their defence to add a limitation defence. And they wished to do that on the basis that the claimants hadn't paid the correct fees when the claims were filed. He refused the application. Again, this is a different case to the present one because, again, in this case, the court accepted the fee and issued the claim, and this happened further down the road. And what in fact had happened in this case is that the claim forms, including fairly modest claims for damages, were filed, fees were paid on that basis, but then later on the particulars, which were filed and served later as they could be, included substantially larger claims. And it was on that basis that the defendant sought to argue that there was an underpayment, and essentially because of that, time hadn't been stopped running for limitation purposes, even though the court had issued the claim. Now, you'll see at paragraph 23, if I can take you there, my lady and my lords, at page 120, where Mr. Justice Stuart Smith describes the central tenet on which they're based, that's the proposed amendments, is that because the claimants paid what may neutrally be called insufficient fees to the court, the proceedings that the court issued did not stop time from running, as I've said. And if I can take you over the page, unsurprisingly at paragraph 24, the judge had some concerns about the consequence of that argument. And in dealing with this, Mr. Justice Stuart Smith reviewed the case law in some detail. With reference to page number 2, I'd like to ask the court to read what was said at paragraph 37 by Mr. Justice Stuart Smith. And sorry, to be more precise, what he said in the last, below the quote, the last part of paragraph 37. Page doesn't suggest that a failure to pay an appropriate fee would not stop limitation from running when the proceedings have been issued by the court. And we respectfully agree with that for obvious reasons. That would create significant difficulties. And indeed, that's one of the areas where we say there's a very clear distinction between that type of scenario and the one that we're concerned with in this type of case. And then if I may take you to page 131 and at paragraph 52, the judge considers two possibilities in terms of what is meant by the appropriate fee. If I may invite you to read that paragraph. I apologise, it's quite long, but it may be faster for the court to read it than for me to seek to read it out. And we then have at paragraph 55, his holding that the appropriate fee, with reference to what he says the principle enunciated in Page and Hewitt, is that the fee required by the relevant order, which is to be determined by reference to the claim or claims articulated in the claim form, and if issued simultaneously, the particulars of claim. In the absence of abusive behaviour, it's not to be determined by reference to claims which are articulated later, whether or not the claims are ones that the claimant hoped or even intended to bring later at the time of issuing proceedings. And then you see, my lady, my lords, at paragraph 56, the judge is considering options available to the court where the correct fee isn't paid. And he notes that the failure to pay the correct fee, if it's identified before issue, the court can simply refuse to issue the proceedings until the fee is paid. And that's precisely what happened here. And lastly, but perhaps most importantly, on Dixon, if I can take you right back to the beginning of the judgment and page 108, paragraph 2, that is Mr. Justice Stuart Smith giving his summary answer of the issues he was asked to determine. Sorry.
Page 108.
Page 108, oh, this is Main Authorities Bundle, tab 9.
Yes.
And he explains that there are two periods. The period between when the claimant submits the claim form and proffers the inadequate fee and when the court issues the proceedings. The failure to proffer the correct fee will prevent the conclusion that an action has been brought for the purposes of the Limitation Act 1980. And then little 2, that is dealing with a different period as to what happens once the court has issued the proceedings. And there, the mere fact that the fee proffered by the claimant and accepted by the court is less than what should have been proffered and accepted for the claim identified, or becomes so because of a subsequent increase in the quantum, does not prevent the action from being brought for the purposes of the Limitation Act 1980. And we would respectfully agree that that must be or respectfully submit that must be the correct analysis. And it is also, we'd respectfully say, an elegant way of distinguishing between these two broadly different scenarios. You'll be relieved to know that there are just two more, and I can be briefer on these. The next case we have is Liddell and Ather Company Solicitors. That's at tab 10, page 138. Judgment of Mr. Justice Turner, the claim related to professional negligence by solicitors. This was another case where the claim had been filed before the expiry of limitation. The issue fee had been accepted by the court, but the claim had actually been issued after the expiry of limitation. And the defendant sought to have the claim struck out on the basis that it transpired that the fee paid and accepted by the court was incorrect because the solicitor had understated the value of the claims. And it was said by the defendant that that postponed the date on which the proceedings were brought to after when they were in fact issued and this limitation had expired. Mr. Justice Turner dismissed the application and held that the claim was brought when the claim form had been received. Importantly, he held that while understating the values of the claim was abusive, the delay in issuing the claim form wasn't connected to that abuse. Now, importantly, with reference to the tour that I've been taking the court on in relation to the High Court decisions, if I can take you to what Mr. Justice Turner said about page number 1, 35 to 38. I think it's right to mention that he took the view that that didn't lay down any principle that a claim won't be brought at the time of the delivery of the claim form unless the appropriate fee has been paid. He made the point that page number 1 simply didn't address that, and that's consistent with what was later said by Lord Justice Lewison. But he interpreted Mr. Justice Hilliard's analysis in page number 2 as being limited to circumstances where tendering the wrong fee caused a delay in issuing the claim form. And you see that at paragraph 43, page 148. It's actually on paragraph 149. I interpret Hilliard J as limiting his analysis in paragraph 57 of his judgment to circumstances in which the tendering of the wrong fee causes a delay in issuing the claim form, as it of course did in this case. He didn't suggest that he disagreed with that analysis as limited to that. And at paragraph 64, I don't think you need to turn it up, but it's fair to note that Mr. Justice Turner did effectively call upon this court to examine the issues that have arisen in the line of High Court authorities that were not entirely consistent on some of these points.
He expressly refused to follow Lewis and Batty.
Lewis and Batty on those particular.
Yeah.
But I would respectfully say that what's important for present purposes is what he said in relation to page number 2 and his reading of what Mr. Justice Hilliard said in scenarios such as those that have arisen in this case. Now, the final point, the final stop on this trip through the authorities is this court's 2021 decision in Hayes and Butters. That's at tab 11, page 159. The underlying claim of harassment proceedings that had been going on for seemingly more than a decade. And the appeal arose from an unsuccessful application to strike out an amended particulars of claim on limitation grounds on the basis that the claimant hadn't, it appears, paid an increased court fee to reflect the increased value of his harassment claim. So again, wasn't a case that was directly concerned with the kinds of issues that arise in this proceeding, not least because it was about amendments in extant proceedings. Lord Justice Peter Jackson, giving the main judgment, dismissed the appeal. He made a number of observations about some of the authorities that I've taken the court to. He also noted that there are inconsistencies between High Court decisions in this area. And I think I need to show you what was said by Lord Justice Peter Jackson at, in particular, at paragraph 24. And the point immediately, so if I may just ask you to read that. drawing these threads together, if I may, my overarching submission is that there is clear authority to the effect that where a claimant has not proffered the appropriate issue fee and the court has not issued the claim, a claim will not be regarded as having been brought for the purposes of the Limitation Act until the appropriate or correct fee is paid and the court then issues proceedings on that basis. In my submission, the analysis in page 2 and Dixon provide clear support for that proposition, and there is nothing in the other decided cases that directly contradicts or undermines that. The tensions between the High Court authorities on our analysis are primarily concerned with situations where after a claim has been issued and the court's accepted an issue fee, there's been a dispute about one of two things. Either a suggestion that there has been an undervaluing of the claim at the outset, and or that the claim included claims for other relief and thus the wrong fee has been paid, or that subsequent developments in the proceedings have increased the value of the claim, potentially requiring the payment of higher court fees. But those, and one can see, I would submit, that those scenarios have given rise to difficulties on the authorities and indeed decisions of the High Court that are not consistent. But I would respectfully submit that whatever tensions exist in the High Court cases, they don't need to be resolved in this case for the reasons that I've given. And my submission would be that if we're correct on the law, then it would submit it necessarily follows that the claim wasn't brought on the 27th of March. If I may turn to my fourth topic, which is grounds 2, 3, and 4. I'm going to deal with these grounds together as they all concern the judge's holding that the correct issue fee, £10,000, was in fact paid on the 27th of March, because either one has to ignore what is said in the particulars of claim, or the claim for an injunction was unintentionally included in the particulars of claim, and that therefore can simply be disregarded. We say that's wrong as a matter of law, and it is also wrong as a matter of fact. The fees order, which I showed you earlier, makes it clear that a fee for a damages claim of the size claimed in this case was £10,000, and that the inclusion of non-money claims required a further payment of £628 as the order stood at that time.
You could only reach the conclusion that the judge has reached that the correct fee was paid if you don't read the particulars of claim together with the claim form.
Yes, my lady, or perhaps if it's somehow held to have been the case that there was no intention to include it, it was somehow a mistake, and that mistake can be addressed through reaching a conclusion of that sort. Yeah. But I would agree, and that's exactly what I'm going to come on to say. As noted earlier by Lord Justice Warby in Butte and Mr. Justice Stuart Smith in Dixon, both made it clear that when assessing what a claim is for and what the correct issue fee is, you have to look at the claim form and the particulars if they're filed together. You've got to look at the full picture. My submission, it was an error of law to ignore the claims for the injunction and indeed the compliance order that was also included, putting to one side the injunction that were contained in the particulars of claim.
Your point about the compliance order, as I understand it, is that even if there had been the kind of mistake that was claimed, it still wouldn't save the claim because the fee would be there.
Precisely so, my lord. It would still have been 10,628 because the compliance order on its own would have attracted the fee of 628 for a non-money claim.
And there's never been a submission, let alone evidence, that the compliance order was an error.
I'm not sure that anything has been said about that, in fairness, my lord.
No. I didn't focus on this when we looked at the claim form. Was there any claim for a compliance order?
No, not on the face
Another
of the
thing
claim.
that only appeared in the claim.
It appears in the particulars, yes. So we said that was an error of law, and it simply ignored the well-established position in at least two High Court authorities, without there being any suggestion from the judge that she considered that those authorities were wrong and that she was purporting to depart from them. We would submit, as I said, that's plainly right, but in any event, it wasn't suggested by the judge that she was departing. Now, the apparent finding that there was no intention to include a claim for an injunction it was, in my submission, wholly unsupported by the evidence, and it was also, in inverted commas, evidenced in a procedurally unfair and improper manner. First, there's no suggestion in the evidence that was filed by the claimant's solicitor in support of the application, in particular the statement of the 7th of April, but also the later statement, that this was indeed the case, that there had been no intention. To the contrary, the claimant's solicitor suggested that, first of all, that not paying the correct fee was an oversight, and she later said that she simply hadn't read the particulars and didn't realise that the claim for an injunction was included. Developments that then followed in the proceedings were entirely inconsistent with a finding, the no intention finding, if I can use that shorthand. In particular, the claimant refiled, as I've said, the claim and particulars of claim, the claim form and particulars of claim, on the 7th of April in identical terms. Despite being aware of this issue, he didn't remove the claim for the injunction. And at that point, he also paid the fee which included the fee for non-money claims, paid the full amount, 10,626. And on the same date, as he refiled that claim, he filed an application for an interim injunction, and as part of that gave evidence averring that damages wouldn't be an adequate remedy. None of those developments are consistent with a conclusion that there was no intention to include a claim for injunctive relief. The evidence of there being such an intention emerged for the first time, I have to say, through counsel, with the respondents having no opportunity to challenge it. Not only was it not in the evidence that was filed late, it emerged from the first time at a hearing. It wasn't even in a skeleton argument. We say that that was clearly procedurally unfair and shouldn't have been permitted. Less still should it have been something that was clearly relied upon.
What was permitted? Because that what counsel says isn't evidence. So what did the judge permit to happen?
Well, took from counsel, I of course entirely agree, my lord, that counsel can't give evidence, but took a statement from counsel as being a sufficient basis for concluding that there wasn't an intention to include a claim for an injunction. And for the reasons I've given, that was inconsistent with the evidence that had been filed, but also with the other circumstances of the proceeding.
And there's another puzzle, because not only can counsel not give evidence, but anything they do assert as a fact, which they weren't party to, has got to be based on some sort of instructions or evidence from someone else. Do we know what was said about that?
We
you
don't.
weren't there,
I've asked whether there is a transcript of the hearing, and I've been told that there isn't one, but those behind me, or perhaps on the other side, will correct me if I'm wrong about that. So I haven't myself seen exactly what was said. But this is referred to in the PTA skeleton, or now appeal skeleton, and there's no suggestion that that was an unfair characterisation. Nothing in the respondent's skeleton that suggests that that isn't in fact what was said. And that, I would respectfully suggest, would have been an appropriate place to take issue with a characterisation of something that had been said at the hearing if it wasn't, on the respondent's view, actually said. Now, even if we're wrong about the judge's finding in respect of the evidence as to no intention to include, My submission is that the intention of the solicitor in question is not legally relevant in any event. One has to make an objective assessment of those claim documents. And we say further, and in any event, there's no suggestion that the claimant or his solicitor didn't intend to include the claim for a compliance order. And so as I've said in answer to my Lord's question, that would have required a higher fee in any event. Now, importantly, we say that if we are right on these points, it follows that when the claim was filed on the 27th of March, it was not accompanied by the appropriate fee. That necessarily follows, we say. And that means, on the basis of the case law I've taken you to, the claim wasn't brought on the 27th of March, it was brought on the 7th of April when the correct fee was proffered and accepted. Topic 5, which is now ground 1. So that's all I was going to say on grounds 2 to 4, unless there's anything else that I can assist the court with on that. Ground 1. The judge decided that she had the jurisdiction to backdate the issue of the claim form. I showed you the way that the backdating application was characterised and what was then decided, and we saw paragraph 4 of the order. We say that there was no jurisdiction to do that. No such power, as I said earlier, was identified in the judgment. There was no grappling with, for example, the CPR 3.10 basis on which the application was put. Now, firstly, and potentially dispositively, as this court held in Bali, the court doesn't have power to backdate the issue of a claim form. That may well be the end of the matter for the purposes of ground 1. But I also just want to deal briefly with the other routes that were relied on and seemingly accepted, or at least they must have been accepted to some degree, because otherwise it's unclear what jurisdiction the court was purporting to exercise. In relation to CPR 3.10, I'll show you briefly if it would assist. That's at authorities 2, 13, page 13. So that is where there's been an error of procedure, such as a failure to comply with a rule or practice direction. The court can make an order remedying the error, as your ladyship and your lordships will know. Now, this was dealt with by Mr. Justice Eyre in not dissimilar circumstances in the case of Peterson and Howard de Walden Estates. If I may ask the court to turn that up, and I promise it's the last authority, it's at tab 12 of the authorities bundle, 173. So this concerned a Part 8 claim that's here referred to as an application for a statutory order, in short, the court granting the claimant a lease that had been agreed. And under the scheme, there was a limitation period of 2 months from when the lease was agreed. And you see that's at paragraph 4. And what happened was that the solicitors acting for the claimant or the applicant filed the claim and at that point offered an issue fee that was insufficient, given that there had been changes in the fees order that they weren't aware of. That happened on the 23rd of March. Limitation expired on the 25th of March. The court rejected the filing and didn't issue the claim form. They informed the solicitors of this in a letter that reached them on the 30th of March. By that point, of course, limitation had expired. And the paragraph references, just for your note, paragraphs 1 and then 15 to 16. What then happened is that the claimant made an application on the same day that they became aware of this for relief from sanction, CPR 3.9, but also for an order under CPR 3.10, validating the step that they had taken and issuing the claim form with a deemed date of issue of the 23rd of March. And you see that at paragraph 21. And the question for the recorder and then for Mr. Justice Eyre on appeal was whether the failure to pay the correct claim fee was an error that could be remedied by CPR 3.10. And Mr. Justice Eyre held that it was not, could not be used in that way. It didn't confer a jurisdiction on the court to do that. That was because the error wasn't a failure to comply with any CPR rule or practice direction, but it was in fact a failure to comply with a step required by the fees order. See, that's at paragraph 41. CPR 3.10 and the civil procedure rules generally concerned with steps taken after the commencement of the proceedings, or at least primarily. And what had happened here was before any proceedings were commenced. You see that at 43 to 44 and 53 for your note. He held that CPR 3.10 cannot be used to give effect to a claim which could not have effect as a matter of substantive law, and that an error of procedure for the purposes of 3.10 doesn't include failing to pay the correct court fee. And sorry, those final two paragraph references, 52 and 58. And in my submission, that reasoning plainly applies with equal force here, to the extent that CPR 3.10 was thought to be engaged, and at least that was the primary basis on which the application was put. I needn't say anything about CPR 3.12M, which was another basis on which the application was put, because that's plainly inapposite on any view, and it doesn't appear that ultimately that was pressed by the claimant. Finally, CPR 3.9, in my submission, it's quite clear that that doesn't apply in this type of scenario. First of all, there's been no breach of a rule, practice, direction or order in the sense recognised by the case law. I don't think that we need to turn it up, but to included in the bundle the recent decision of Lord Justice Burse in Yes Electrical. For your note, that's at Authorities tab 13, page 192, and in particular what His Lordship says at paragraphs 25 to 33 emphasises the important point that, of course, there must be a breach of a rule, practice, direction or order before one is even potentially in CPR 3.9 territory. We say that's dispositive, but in any event, CPR 3.9 doesn't apply for the further reason that there's no sanction provided for under any applicable rule, nor is there any implied sanction. And indeed, that's precisely what Mr. Justice Eyre held in the Peterson case that we've just been looking at page 20, paragraph 28. And CPR 3.9 is also inapplicable because, for essentially the reasons that were given with reference to 3.10 about matters taking place before there are any proceedings before the court. So pulling all of those threads together, in my submission, the court had no jurisdiction to grant the backdating application. And just 4 very brief points to make on the respondent's notice, topic 6, and his skeleton. He says there that the court made a procedural error in rejecting the claim. That argument didn't feature in the backdating application, and it's wrong for the reasons I've addressed you on in terms of what's required for a claim to be brought. It proceeds on the mistaken basis that the issue fee for a non-money claim needs only to be paid if an application for interim relief and an accompanying N244, what he calls a formal application for an injunction is made. That's clearly wrong for the reasons I've already addressed you on. The rejection of the claim had nothing to do with not issuing an application notice with the claim for an injunction. That's a fundamental misunderstanding of why the court rejected the claim. And these are themes that persist throughout the respondent's notice and the skeleton. And the heavy reliance on CPR 3.9 is misplaced for the reasons I've already given. Sorry I took slightly longer than planned. That is all I was going to say at this point. We would invite the court to allow the appeal and to substitute the relevant parts of the order for an order dismissing the backdating application, granting my clients their costs of and occasioned by that application, and to declare that the proceedings were brought for the purposes of limitation on the 7th of April. Unless I can assist the court further, that is all I propose saying for the moment.
I just ask this. The first instance authorities have shown us are not binding on us, obviously. So the question is up for grabs in this court. Would you? Am I right in thinking you'd say the only authority which is binding on us is is Barnes and St Helens, which was 2006, where Lord Justice Tuckey identified the rationale for describing or defining what brought means, namely it's everything within the claimant's power. Is that the only thing, the only principle that's binding on us?
That we would say that's the only appellate authority that's binding. Certainly there's no Bristol aeroplane issue that we accept that would be binding. And I suppose that we also have the probably obiter remarks of Lord Justice Peter Jackson in Butters.
Yeah.
They're clearly obiter.
There's possibly another, and also possibly obiter, point in paragraph 87 of Gotti and Perrott.
Sorry, my lord. Gotti, yes, we didn't go to Gotti.
Gotti, but the point you would have made, I dare say, is that Lord Justice Cobb said in paragraph 87 that Mr. Sayre had rightly held that CPR 3.10 couldn't come to the claimant's aid in relation to matters that had occurred or not occurred prior to proceedings.
Sorry, yes, essentially approving what was said in Peterson. I neglected to mention that.
It may also be obiter. That could be debated, I suppose.
Anything else? No. Thank you very much. This was some
M'lady, the respondent's position is that the Deputy High Court Judge's conclusion, which is summarised at paragraphs 16 to 17 and 24 of her judgment, I'll come to those paragraphs in a minute, that the claim had been brought on the 27th of March 2025 is correct for 3 reasons. First of all, that the court had jurisdiction to determine whether the claim had been brought on the 27th of March 2025 for the purposes of the Limitation Act 1980. And that's to address ground 1 that was one of the latter submissions made by my then friend. Second, that the court's conclusion that there had been no error in relation to the court fee paid on the 27th of March 2025 was correct. And thirdly, in the alternative, if that's wrong and the court fee paid was incorrect, that the claim was still brought in time as an inadvertent failure to pay the correct court fee does not lead to a claim being not brought for the purposes of the Limitation Act 1980. And that's to confront head-on what was said in Hayes and Butters and see the first instance decisions that my then friend has very helpfully gone through. So, my lady, dealing first of all with the issue of jurisdiction, and that's the first point, and I think that can be dealt with relatively more briefly than the other 2 points. The appellant says, and this is ground 1, that the judge erred in law in finding that she had jurisdiction to grant the backdating application and deem the claim to have been brought on the 27th of March 2025 on the basis of, and then the 3 bases are set out, CPR 3.10, CPR 3.9, and then there is the reference to any general discretion which led to a finding that the error resulting in the rejection of the claim was the unintended inclusion of a claim for an injunction, not a failure to pay the appropriate court fee.
Well, it didn't help that the application, the backdating application, referred to the date of issue.
Yeah.
So it was all put before the judge on a very muddled basis. But if you strip away 3.9, 3.10 and the rest of it, your point is that the court could look into and declare whether the claim was time barred or not.
Yeah, well, that's exactly right, and that is really cutting to the chase. It's completely right that as before the judge, matters were somewhat confused. As the application form, as my learned friend noted before, referred to 3.9 and 3.10, albeit also referring to the court's inherent jurisdiction.
Yes.
And of course, there was also an overlapping of language and a confusion of language in the judgment, presumably at the hearing, in relation to issue and bringing the claim, which again, 2 separate concepts, completely accept my learned friend's submissions in that regard.
But you can pray and aid the fact that what is actually recorded in the body of the order is that it was brought in time.
Yeah, well, that was what I was going to take you to. That's paragraph 5 of the order, page 45 of the core bundle, and that's exactly, and perhaps can even shortcut even further what I was going to say here. It's the respondent's case that what the judge has done is appropriately declare, for the purposes of the 1980 Act, that the claim was brought as of the 27th of March 2025. The court has the jurisdiction to make such declarations. That's basic principles, but I've given you, I don't necessarily draw it up, the case, this is the Supplementary Authorities Bundle of Credit Agricole Corporate and Investment Bank against Persons Unknown, 2025, EWHC 1346. Tab 5 of the Supplementary Authorities Bundle, paragraph 74, which of that Authorities Bundle is page 61 electronically. And that just reminds us that the power or the jurisdiction to grant declaratory relief comes from section 19 of the Senior Courts Act and preserves the jurisdiction of the High Court. Tells us also that declaratory, and this is 4 or 5 lines down, declaratory relief can be granted whether or not any other remedy is claimed, and the power to make declarations is a discretionary power where there's a real dilemma which requires the court's intervention. And the last 3 lines, as between the parties to a claim, the court can grant a declaration as to their rights, or as to the existence of facts, or as to a principle of law. And in my submission, that's exactly the position we're in now. It's a real dilemma. Has this claim been brought in time for the purposes of the Limitation Act? That's an issue properly before the judge, and the judge is entitled to make a declaration to that effect. Has the jurisdiction to do so, subject, of course, to whether, as a matter of law, the judge's conclusion on that matter was correct. And just one other thing to say, and I don't seek to disagree too much with my learned friend's submissions that the judgment does get itself somewhat confused, but it is important to note that when the judge is going through her analysis, she has very much in mind the order of Deputy High Court Judge Eardley, Casey, and you can see that, for example, in the core bundle, paragraph 11 of her judgment, that's page 48 of the core bundle, where you can see that the judge explicitly cites the key passage of the Deputy High Court Judge's order, entitled C, where he sets out the correct legal position. So that is very much in the judge's mind. And then just in terms of the 2 or 3 operative passages of her judgment, you can see the conclusion. It's on the same page at the bottom, at paragraph 16, That is her conclusion. The claim form is refiled on the 7th of April 2025. It's not changed. Talks about a separate N244 claims filed on that date with a separate fee for injunctive relief, which has now been withdrawn. There is therefore no material difference between the claim form filed on the 27th of March and that on the 7th of April, and the fee for the claim form has effectively remained at £10,000, whilst the fee for the N244 was the additional fee related to injunctive
Well,
relief.
you'll have to deal with the muddle over that.
Yeah.
It does look, doesn't it, as if she's treating the fee as payable in respect of the claim form,
Yeah.
rather than the claim. Which
And I'm going to address. That's my second topic, and I'm going to address you. And I say, as a matter of law, that is correct. I was a little bit of dismay when, my lord, when I noticed obviously you were on the bench today, and of course it's a decision of Asgar and Patrick.
I'm very open-minded about whether I was wrong in something I've said before.
Okay. Well, in any event, I confront that. I will confront that as my second topic, and it is my submission that the fee paid is referable only to the claim form, not to the claim form and particulars of claim where the particulars are served.
Can I just ask a factual question? You may not be able to answer this because I'm very conscious that neither of you were there.
Yeah.
What prompted this application? Because you say it's a legitimate issue to raise, but normally, if you're right, there was no need for any of this because the claim was brought in time.
Yeah.
And it was for the defence to raise limitation because it's a bar, it doesn't deprive the court of jurisdiction.
Yeah.
And unless and until they'd done that, there was no need for any of this.
Yeah. I mean, I can take some instructions.
Yeah.
Okay. Well, it's on advice.
Okay. Well, I shall inquire further.
Yeah. No,
I mean, it clearly wasn't brought on the basis that we were asking for a declaration that was brought in time. That wasn't the basis of the application, was it? It was asking the court to make some form of order.
Yeah.
Curing something, yes.
Yeah. I accept that. Look, I can't get away from the fact that it's all rather confused on the application form. What I rely on is might be described as scraps, but it's clear that there's a reference to inherent jurisdiction in the judge.
You say the bottom line is the judge did something that she was entitled to do, and if you manage to get round the obstacles in relation to the fact that the particulars of claim happen to be served at the same time as the claim form, you say, well, then the right fee was paid, and even if we're wrong, that's not part of the test in any event, and all the first instance judgments that suggest the contrary are wrong.
Yeah, or the court may just decide they want to take a different approach, as has been suggested by Lord Justice Jackson. And that's my third argument, yeah. So, well, my lady, given what's just been said, I don't think I need to say anything more in relation to topic one. Really, the key issue before the court, the key two issues before the court are the issue of whether the correct fee has been paid, and indeed the issue about whether that matters at all in any event. So moving on to point two, was the correct fee paid? So the respondent's position is that the correct fee was paid, and that's because the claim form referred to a money claim in excess of £200,000. That meant that a fee of £10,000 was correctly incurred, which was paid. Whilst the particulars of claim referred to an injunction, the claim form provided to the court made no reference to an injunction or indeed to any other relief other than the claim for money. Accordingly, whilst the £10,000 fee was payable for the money claim, it's the respondent's submission that no additional fee was payable in relation to the injunction application or indeed in relation to any other remedy which appears in a particular claim. In that regard, of course, referred to the data protection remedy that my learned friend referred to.
Well, that can't be completely right. It might be right at least as far as issue is concerned, or at the time of issue. But if you were to serve particulars of claim seeking injunctive relief further down the line, you'd surely have to pay an extra fee for that.
I accept that. Yes, this submission.
But would you then have to amend your claim form to include that relief?
Well, that may be the necessary.
That might be the answer.
Yeah. But for the purpose,
it out there.
Yeah, but for the purposes of paying the fee, which allows for the court to issue the claim,
Yeah.
the reference point is what is on the claim form,
Yes.
not what appears on the particulars of claim. And there are 6 stages to my argument in this regard. The starting point, the first stage, is the Civil Proceedings Fees Order 2008, and that appears at tab 3 of the authorities bundle, which electronically is page 20. So we have there Article 1, and we can see that at Article 1 brackets D, expressions also used in the CPR have the same meaning as in those rules, and that's obviously reference to civil procedure rules. Then we have Article 2, so just one page down. This provides that the fees in a relevant column of Schedule 1 are payable in respect of the items described in Column 1, in accordance with and subject to the directions specified in that column. And then we go to Schedule 1 and the table, and that appears at page 22 onwards in the authorities bundle. And in Column 1, we can see there is, and this is 1.1, so this is right towards the top, it says, on starting proceedings, brackets including proceedings issued, but that's irrelevant for parent purposes, to recover a sum of money where the sum claimed and then the applicable sum in this case would be letter I, exceeds £200,000 or is not limited, and then it tells us that the fee is £10,000. Emphasise on starting proceedings there. I'll come back to that in a moment. Then we just go a few rows down on the same page. We have 1.5. Says again, on starting proceedings for any other remedy in the High Court, we go down to the next line, and then that's the fee of £626. And then for the sake of completeness, and I think my own friend's probably taken to you this already, there's no dispute that if you go over to the next page at 23, and it's 3 rows down, where a claim for money is additional to a non-money claim, other than in relation to recovery of land or goods, then fee 1.1 is payable in relation to fee 1.5. Okay, so that sets our context, and we see the language that's being used there in the order, and remind ourselves that there is a reference to looking for consistency between what's being said in the order and what's being said in the CPR. The next reference, this is the second stage, is to move to civil procedure rules, and in particular CPR 7.2, and that we find in the authorities bundle at page 14. And so, heading, how to start proceedings. 1. Proceedings are started when the court issues a claim form at the request of the claimant. 2. A claim form is issued on the date entered on the form by the court. This obviously accords with the general understanding that it's the claim form which is the key document constituting the originating process. Third stage, and relatedly, it's important to remember that the particulars of claim have no role in starting proceedings. Whilst in this case the particulars of claim were filed electronically alongside the claim form, there was, and I think the court's already referred to this, absolutely no necessity to do so. And we can see that from CPR 7.4, which is page 15, the next page of the authorities bundle. And this gives us the options for the particulars of claim. 7.4 brackets 1, particulars of claim must A, and this gives us 2 options, be contained in or served with the claim form. So they can be attached to the claim form, which is what happened in this case. Or, they don't have to be attached, but when you, remember at the moment we're talking about filing, but when they then get sent out when it's served, so potentially 4 months or so later. Or the third option is that you can serve the claim form separately from the particulars of the claim, provided, and obviously subject to the fact that you're not at the latest time for serving, you send the defendant the particulars of claim 14 days later. So there's 3 options. But the key point is that it's the claim form, not the particulars of the claim, which has the role in starting proceedings. And then just for completeness, because I think it was referred to by the court during the course of my learned friend submissions, we have CPR 7.5, which is in the supplementary authorities bundle at page 2. And this informs us or reminds us that when one's talking about service of a claim form on an individual, and it's that which confers jurisdiction on an individual, it's service of the claim form, again, which is the key and the important document. And we have the table there which tells parties what steps need to be done by the relevant period of time. So it follows in my submission that when the fees order is talking about starting proceedings to recover a sum of money or for any other remedy, the focus is on the thing that's starting proceedings, and that is the claim form, not the particulars of claim. And in particular, I should say, not the particulars of the claim, where the particulars of the claim is a separate document. And I accept it was sent in with the claim form, but these are 2 documents. You do sometimes, on very simple claims, see a party just simply embed in the claim form particulars. But in my submission, the proper construction of that is that's simply the claim form, just set out in more detail than it might normally be. So that's the 3rd stage. The 4th stage is that the focus on the claim form is equally consistent with the applicable provisions of Practice Direction 51.0 of the CPR, which was applicable at the relevant time. So this is the Practice Direction that deals with electronic working. That's now been replaced, my understanding, as of October 2025, and the relevant Practice Direction now is Practice Direction 5C, but at the time we were still dealing with 51.0. And the main and material provisions of the scheme are set out in the supplementary authorities bundle, starting it's tab 3 of the supplementary authorities bundle. And if we start, first of all, looking at page 25, and if we go to, and it's in the middle of the page, paragraph 2.3, to file a document using electronic working, a party shall, and it just talks about accessing the website, and then D, upload the appropriate document, and E, pay the appropriate fee. Then we go to paragraph 5.1 of the practice direction. This is on page 27 of the supplementary authorities bundle, just towards the top, and it comes under the heading General Rules regarding issue and filing. It says that any document which is filed using electronic working then must, and then we got D, be categorised or labelled as the type of document that it is, e.g. claim form or witness statement, exhibit, and numbered sequentially. So focus there is on what is the document that you're seeking to file. Example, claim form. Then, if we just go on the same page down to 5.3, we see the process that was occurring in relation to documents. And 5.3.1 refers to the submission of any document will generate an automatic notification acknowledging that document has been submitted prior to being accepted. There are then references at 5.3 brackets 2 to the court having the ability to remedy an error of proceeding made whilst using electronic working. When the court makes such an order, a document filing will not fail acceptance because of the error of procedure made. And then at 5.3 explains how court staff may refuse to include a submitted document if there are problems with it. For example, it's been scanned or saved upside down.
You have to upload it again.
Yeah. So then we go to 5.4.
That talks about the fees.
Yeah, this is the fee. So 5.4.1, where payment of a court fee is required to accompany the filing of a document, the date and time of the filing on electronic working will be deemed to be the date and time at which the payment of the court fee is made using electronic working. And then 2, the date and time of payment will also be the date and time of issue for all claim forms and other originating processes using electronic working. So, again there, in my submission, the focus is on the particular document and the fee paid in relation to that particular document. In this instance, we're talking about the claim form. And then just finally, just for completeness, although it's not necessarily completely material for the argument, you can see that at 5.6, if a submission fails acceptance, notice for reasons of failure will be given to the party on their electronic working account, and if the submission was of a claim form, appeal notice or other document required to be issued, it will be deemed not to have been issued. And then 7 talks about refunding. And then finally, we have under 6.1, just at the bottom of page 28, under the heading Payment of Fees, where any rule or practice direction provides for a fee to be paid, party filing a document using electronic working must, except in circumstances specified in subparagraph 4, pay the appropriate fee by credit card or using the relevant account. And then there are various exceptions given to that. And indeed, at 6.2, there's the reference to help with fees that I think the court was referring to earlier. So, in my submission, it is apparent from that review of the practice direction and the electronic working scheme that where a fee is required, the payment of a fee is connected to the filing of a particular document. The date and time of payment of the required fee will be the date and time of issue for the purposes of the CPR when you're dealing with a claim form. And in relation to other document filings, the submission date will be the relevant date on which they're filed on the system. Thus, in my submission, the applicable scheme, as set out by the practice direction, clearly places a focus on individual documents. And insofar as a claim form is concerned, the focus is thus on the fee applicable to that document, not to a claim in a general sense, as construed in light of other material, such as particulars of claim. It's focus on the document. So that's the 4th stage. 5th stage of the argument relates to the requirements of what is put in a claim form and in a particulars of claim as set out in the CPR. And in that regard, I have reference to CPR 16, and that can be found, the relevant bit 16.2 is at page 3 of the Supplementary Authorities bundle. So, 16.2, 1. This is the mandating what a claim form must have. Claim form must, 1A, contain a concise statement of the nature of the claim. B, specify the remedy which a claimant seeks.
So if you were claiming an injunction, it should be in the claim form.
Precisely. And it is relevant to, but having said that, it is relevant to note that if you go down over to the top of page 4, it's the last sub-para of 16.2, the court may grant any remedy to which the claimant is entitled, even if that remedy is not specified in the claim form. And presumably that would be, gives the court in the event that something comes up in the context of a claim, that doesn't restrict or fetter a court's ability to make a...
No, but strictly speaking, if you wanted a permanent or final injunction,
Yeah.
you would have to amend your claim form.
Yeah, absolutely. And in my submission, when one contrasts that with what we look at is required for a particulars of claim, that again gives us the indication as to the relevance of what's in the claim form as opposed to looking at it more globally. And then if we look therefore at page 5 of the supplementary authorities bundle, and this is 16.4 contents of the claim form. Sorry, the particulars of claim. Apologies. And it is notable that although at 16.4, it gives us at 16.4 brackets 1 tells us what a particulars of claim must contain, and you'll see there in terms of what is mandated that there is no reference there to having to set out any remedies sought, subject to there is a reference if you're seeking to ask for aggravated or exemplary damages, then you have to have a statement to that effect set out in the particulars of claim. It is true to say that the reference at 64 brackets 1 brackets E talks about other stuff that needs to be set out in a practice direction. So a practice direction, relevant practice direction, may set out requirements for what should be in a particulars of claim. And for the sake of completeness, obviously this is a media and communication claim, the current case, and it is therefore relevant to look at what is said in practice direction 53B. And apologies, I don't quite know why when it's come out on the printer it's come out quite so unclear, but it is hopefully probably readable. Two things to point out. That in relation to, and this, I'll give the caveat in it because I'm going to come on to the data protection claim, so that has come up today. But in all other heads of claim, there is no requirement to identify any damages in the particulars of claim other than, any remedies in the particulars of claim other than damages, albeit for, you look at the requirement for a data protection claim, which is, that is page 18. It's right at the bottom of that page, paragraph 9. In a claim for breach of any data protection legislation, the claimant must specify in the particulars of claim, and there it does say for the remedies which the claimant seeks. But so that's clearly there, but in relation to one particular area of heads of claim. But in my submission, it's clear from the provisions of the CPR that the express remedies sought by a claimant must be set out in the claim form. That is where the focus should be for the purpose of determining what remedies are sought. Albeit the court's ultimate ability to order alternate or additional remedies is not constrained by what's set out in the claim form. But of course, if that were to be the case, then as Milady, you pointed out, then there should be an amendment potentially to the claim form, or at the very least there should be payment of the additional and relevant court fee. And of course that does happen in cases, even in cases where, for example, the court, a court fee has been paid for a claim that may be worth £50,000. In the course of proceedings it becomes apparent that it may be worth manifestly more. And there is case law which indicates that parties are in a position at that point to pay an additional court fee, provided that the underpayment in the first place was not abusive, not deliberately underpaid to gain an advantage.
Can you remind me, please, whether the claim form, as opposed to the particulars of claim, made a claim for relief under the Data Protection Act?
No.
Didn't.
I will double check.
So it's just damages?
Yeah.
Thank you.
And everything that I've said there in my submission is consistent, which is helpful, with the White Book, commentary in the White Book. And I've given you the passage in the White Book at page 83 of the supplementary. Authorities bundle, and it's under the heading specify the remedy which claimant seeks, and then you'll see that it's the middle passage. Rule 16.2 brackets 5 provides that the remedies which the court may subsequently grant to the claimant are not limited to the remedies specified in the claim form. It is, therefore, not necessary for a claimant to include claims for further or other relief in their claim form. Indeed, to do so may, in some circumstances, cause them to have to pay an additional court fee on the issue of the claim. And then it refers to the fees order and case of Batty.
But if you are seeking relief, this is the puzzle in my mind at the moment. It's all very interesting. If the obligation is to specify in the claim form the remedies that you're seeking,
yeah,
and your particulars of claim tell us that you're seeking an injunction,
yeah,
on your argument, you're in breach of the rule by not including that claim in the claim form. That has no consequences.
No consequence for the purposes of determining whether the correct fee has been paid at the point in time that the court is considering whether it's that question as to whether the appropriate fee has been paid.
So that claim is free. The £620 never gets paid.
No, well, at the point in so you pay your if it's in the claim form,
yeah,
you pay your court fee which relates to what's referenced in the claim form. It may then be said, well, hang on a second. And the court will issue the claim form on the basis of what's there, and it's a money claim. Now, particulars of claim either serve with or serve separately. Someone says, well, hang on a second. You're also asking for an injunction. There is a requirement to pay a further £626.
Why?
Because
we're operating by reference to what's.
Well, actually, no. That actually, my lord, that's actually a very good point. That in the sense that the reference to starting proceedings, it relates to the claim form. Yeah.
Your argument seems to have the seeds of its own undoing embedded within it, because you on your argument, the authors of the fees order intended to permit someone to add a claim for relief in their particulars of claim without paying the fee that would have been payable had they included it as the rules require them to do in the claim form.
But if you then, there then could be, well, I mean, the one way of construing that is that you say, well, you've started proceedings, and then effectively, if you're saying in your particulars of claim that it's not in your claim form, we also have a claim for an injunction, that's effectively saying, well, we have a claim for an injunction, which wanted to be heard, obviously, as part of these proceedings, but it wasn't put in the claim form, so it's effectively a claim for an injunction, therefore we pay the fee which relates to that.
It may be that the answer is you've got to amend your claim form, and then you've got to pay the fee, but we haven't looked at the provisions about that, and they're covered in one of the cases, aren't they? In the recent case.
Yeah. Well,
anyway, it's an interesting area which I haven't thought through, as you all have gathered.
Well, I can see lunchtime's coming out, so I'll have an opportunity to have a quick look at that in a moment. So support for certainly for my proposition in the commentary from the White Book, and then finally, of course, it's necessary for me to address what a Lord's judgment in Batty and the way that has been adopted by Mr. Justice Stuart Smith, as he then was in Dixon. Of course,
I don't want you to feel rushed in dealing with
Yeah, I was
that.
wondering, I thought maybe I'll stop at that point because that would probably take 10-15 minutes or so, and perhaps better to do that after lunch.
Should we do that at 2 o'clock?
Yeah.
You might say it was all per incuriam because no one argued these points at the time.
Well, that's actually what I was going to say that, yeah.
My lord has a question.
Just one question on the fees order. Just think about this over lunch. Might it be possible, right, to read the reference to starting proceedings, particularly after we've been through all the rules we've just been through, as being when you start the particular part of the proceeding. If you start proceedings including money claim in the claim form, well, that's when you start proceedings.
Yeah.
But if you include a claim in your particulars of claim for an injunction, then you start the proceedings for that injunction when you put it in your claim form, and that may be when it accompanies the claim form or when it's subsequently.
And that fits the analysis of that there should be potentially an obligation to amend your claim form to. Well, there must be because it's mandatory that the remedies that you seek should be in the claim form. So one.
Well, the point it cuts both ways because then it could be said you have started the proceedings for the purposes of the fees order.
Yeah.
By including a claim for an injunction in your particulars of claim.
Well, except that well, perhaps shall I deal with that after lunch? Yeah. Okay, grateful.
Right, 2 o'clock. Thank you.
All right, Evil.